What comes into your mind when you hear this? It is not what you know. It is what you can prove in court. I will tell you what comes into my mind. Assume it is on a Friday morning, and when you step into your office, you receive a call from a client. She informs you that she has just been arrested. She has been placed in a cell and she has been denied bail. She has been informed that she will be produced in court on Monday when she will be charged. Further, she informs you that she is a breastfeeding mother of a child of 3 months of age. Now, even without further details, you can feel the injustice that has been done by the police. And if you have some knowledge on the Constitution, you know that there are some rights, human rights, which have been violated. But is proving those violations as easy as perceiving them? The answer is no. Well, you may hope that even the judge who will hear the application or the petition you are going to file will see the injustice. The injustice is self-evident. But you cannot rely on that hope that the judge will see the injustice. Actually, it is a rule of drafting constitutional petitions that you must specify the provisions of the Constitution or the law which were violated and the manner in which they were violated. This is where it gets tricky, because the way the Constitution is drafted, the provisions are wide enough to accommodate multiple interpretations. Of course, you go and say that the rights of the child have been violated. You say that the rights of this arrested person, who is now your client, have been violated. But when the respondents, now the police officers, the IG come in, they also rely on the same Constitution to argue that they complied with their mandate. They will say it is our mandate to ensure that there is law and order. It is our mandate to arrest and to take to court any person who is suspected of having committed an offense, and so forth. So it is not as simple. It is an act where now the court will have to weigh your argument versus the argument of the respondent. Now, to solve this problem, especially in these constitutional petitions where the ODPP and the police are the respondents, there is a better way of dealing with them. Instead of relying on the wide provisions of the Constitution, you can go to other resources which give you more specific application of the law. To demonstrate this, maybe if you have a constitutional petition where you are saying a certain person was arrested unjustly, if you go to Article 29 of the Constitution, you find that it says that every person has the right not to be deprived of freedom arbitrarily or without just cause. Now, if you present only this to court, then the question will be, what is arbitrary and what is without just cause? It is complicated. Each party will say on your part you say this arrest was arbitrary and it was without a just cause. On the other hand, the respondents will say there was a just cause, and you keep arguing and you don't have an edge over the respondents. But if now you go to the rules or the regulations which were made to comply with this constitutional provision, you get more specific provisions. I'm talking about the standing orders of the National Police Service, and I'm also talking about the decision to charge guidelines of the ODPP. The good thing with the two is that they are made to align with the Constitution. And therefore, the ODPP has already interpreted what his obligations are under the Constitution and given specific measures that must be taken to ensure that there is compliance with that constitutional provision. The same with the National Police Service. So, instead, in the case I was talking about it is a hypothetical case. It is not that there is a client who is suffering that, but it happens. Now, in this instance, when you have this client who has a child at home and so forth, yes, list what the Constitution says, but go to the National Police Service standing orders and look at what it says about dealing with women who are arrested or who are suspected of having committed an offense, women who have dependents at home, how to deal with women who has committed or who is suspected to have committed an offense in the nature of the one that your client is charged with. Now, when you go to the standing orders and you see that a police officer is required not to detain any female for a petty offense. So it is not a matter of granting bail. You should not detain a woman for a petty offense. In that case, if your client was detained for a petty offense, and a petty offense does not necessarily mean that it is one which is punishable by fine only or by 6 months, by less than 6 months imprisonment. It can mean something else. For example, if the woman just had a physical fight at the trading center, that is an offense of affray, and it attracts a penalty of up to 1 year imprisonment. So in this case, it may not be the offense which is indicated in the Constitution, Article 49, that it is less than 6 months imprisonment or a fine only. It could be more, but it is still petty because it is defined. First, it is defined, affray is defined as a misdemeanor. And secondly, depending on how the fight was, maybe there were no injuries, maybe the parties were intoxicated, the other party was intoxicated or something. Depending on circumstances, it can be a petty offense. So when you look at these provisions of the standing orders, you may see that this is a petty offense and this woman should not be held in custody, should not be detained. It is not that you should detain them and then release them on cash bail. There should be no detention. Now, when you take this to court and inform the court, this is what their own standing orders prescribe. You find another prescription saying that the police officer should find out if there are any dependents at home when you arrest a female person. So if this did not happen, this is a good provision to bring to court to show that there was violation. Similarly, if you go to the decision to charge guidelines of the ODPP, you find similar things. You find that while Article 157 can be used either way, you can use it to argue that the ODPP violated some rights or the provisions of the Constitution, and at the same time, the ODPP can argue that, basing the argument on the same provision, they can argue that they complied with the Constitution. But now when you go to the guidelines, which are very specific, you find there are particular things that they must do. For instance, if you go to the Constitution, you find that the accused person has the right to be supplied with the evidence to be relied on. Full stop. Once you go to the decision to charge guidelines, you find very specific provisions. You find that immediately a prosecutor receives an investigation file from the police, the first thing he should or she should ensure is that the file is complete, and the completeness of the file is defined. It is indicated there must be the initial report, the investigation diary, summary of the facts, and so forth. These things must be in this file. So when you go to court and tell the court, my rights are to be given the evidence that will be relied on has been violated since the prosecution did not supply me with the initial report or the investigation diary, then you have the basis on which you can tell the court this is the weighing balance. This would not be possible when you are using the Constitution alone. Another thing that the decision to charge guidelines provide for is the weighing of the evidence itself. So let's say the file is complete, but now the prosecutor is required to look at the evidence provided by the complainant in form of the witness statement and the other evidence and see whether there is congruence. So if you had a case where a person comes in and says, I was assaulted by the accused person on the 3rd of January, and then the same person produces medical documents dated 1st January showing the treatment he underwent after the assault, then there is a lack of congruence in the two. And of course, the prosecutor should not approve such charges. Now, if you just argue from the point of the Constitution, the prosecutor will come and say, we are independent. We decide, the Constitution gives us the mandate to decide whom to charge and whom not to charge. But now, once you go to their own guidelines, you find that there is a specific provision which will save your case, and there will be retro argument. The prosecution will not, or the prosecutor will not have the benefit of doubt, which he or she could be granted when you use the Constitution alone. Now, the most important thing, as I said, about these two documents is that they are binding. They are binding on the prosecutors, they are binding on the police officers. And if you look at the decision to charge guidelines of the ODPP, they provide as follows. The decision to charge guidelines are anchored on Article 147 of the Constitution 2010. national prosecution policy, and the general prosecution's guidelines. It provides the framework of exercising the state power of prosecution, ensuring justice is served to all and sundry. All prosecutors have a legal duty to comply with all guidelines and instructions issued by the DPP in respect to prosecution. So it means that they are binding. And there is a very interesting case that is Republic versus Director of Public Prosecution and others, ex parte IO, AYOO. It is a decision by Justice Chigiti. And it explains that the guidelines should be applied not only to guide the prosecutor, but also for the benefit of everyone. So a prosecutor cannot just disown the guidelines. They have to apply them. So when it requires something to be done, it should be done. Similarly, if you go to the standing orders of the National Police Service, you find a similar statement saying that every member of the service should be thoroughly familiar with the contents of the orders immediately upon appointment and at all times throughout their professional career in the service. So two things, they are bound, and these documents, these guidelines and these standing orders come directly from the Constitution. They only enhance the provisions of the Constitution. So when you are making a constitutional petition, especially against the ODPP and the National Police or the Inspector General of the Police, it is important that you rely on the two. I know that the standing orders are bulky, as they are over 1,000 pages. But again, I think what an advocate should do is familiarize himself or herself with the guidelines and the standing orders before even a matter arises. Because what happens is that, as I was saying, this you get this matter on Friday morning. You want to file the petition as earliest as possible, so that by evening you have the orders for the release of your client. So you don't have much time. You don't have the time to go through 1,000 pages looking at the relevant parts of the standing orders. So what do? You study them beforehand and you note down the provisions which would apply when such a matter comes up.